All right, and welcome while we read about the Judiciary Act of 1789. And this is where the United States sets up the court system, so the lower courts beneath the Supreme Court. And this became law on September 24th, 1789. The Judiciary Act of 1789 was created during the first session of the first United States Congress. It established the federal judiciary of the United States. Article 3, Section 1 of the Constitution prescribed that the judicial power of the United States shall be vested in one Supreme Court and such inferior courts. These are those inferior courts. It made no description for how the courts would work, leaving this to Congress to decide. The existence of a separate federal judiciary had been controversial during the debates over the ratification of the Constitution. Anti-federalists had denounced the judicial power as a potential instrument of national tyranny. Indeed, of the 10 amendments that eventually became the Bill of Rights, 5, this would be Amendments 4 through 8, dealt primarily with defending people from the courts. Even after ratification, some opponents of a strong judiciary urged that the federal court system be limited to a Supreme Court and perhaps local judges. The Congress decided to establish a larger system of federal trial courts, thereby creating a way to enforce national laws within each state. Okay, now this next part is going to be very helpful for you to learn for future concepts. This image right here says writ of mandamus. What is a writ of mandamus? Well, the image says mandamus is a Latin word which means we command. Mandamus is an order from a superior court to a lower court or tribunal or public authority to perform an act which falls within its duty. Simply put, a writ of mandamus is a writ, a piece of paper issued to a public official to do a thing which is part of his official duty, but which he has failed to do so far. This writ cannot be claimed as a matter of right. It is the discretionary power of a court to issue such writs. Power of judicial review. A clause which is a part of the Act, so the Act of the Judiciary Act of 1789. A clause, a part of this act, granted the Supreme Court the power to issue writs of mandamus, which was declared eventually unconstitutional. In the court case Marbury versus Madison, one of the seminal, most important cases in American law, the Supreme Court held that it was unconstitutional because it purported to enlarge the original powers of the Supreme Court beyond that permitted in the Constitution. This next part is very important. The case was the first that clearly established that the judiciary, the system of courts, can and must interpret what the Constitution permits and invalidate laws which are contrary to the Constitution. The Judiciary Act of 1789 was the first act of Congress to be partially invalidated by the Supreme Court. So simply put, the Judiciary Act of 1789, in part of it, it gave the Supreme Court too much power. And the Supreme Court said the point of the Supreme Court is to say whether a court case agrees or disagrees with the Constitution. And if it disagrees, it's bad. Can't happen. So this is the first time the Supreme Court said this part of a law is bad and must go away. It invalidated that law. Well, hopefully this is helpful and you're learning a lot.